Judge Schippers, I apologize to you that I wasn't here when you came in.
That's in order,
Good
Chief
morning
Justice.
to you.
Good morning, Chief Justice.
Are you well?
I'm well, thank you.
Are you relaxed?
Well, as relaxed as I can be.
All right, okay. Now, you hold two master's degrees, one from UCT, the other from Harvard. Is that correct?
That's correct, Chief Justice.
I noticed that you practiced in the US for how long?
For just on a year,
1 year.
yes.
And how did you become the member of the New York Bar, even as a judge?
Well, I took the New York Bar exam while I was in the United States. And you can only take the exam when, in fact, you have an American qualification. So my Harvard qualification entitled me to take the exam. And I'm still a member of the New York Bar, but not a practicing member. And the New York Bar authorities allow us, by virtue of, even as judges, to remain members as long as we pay our dues. So I do that biannually. And I'm also exempted from the continuous legal education, which is a requirement in the US, by virtue of the fact that I'm on the bench.
But while you were practicing, was it a rewarding experience?
It was a tremendously rewarding experience, Chief Justice, because I was exposed to international law, something which I'd never done. I worked at a firm in Washington, D.C. called Fulbright and Jaworski. Leon Jaworski was the prosecutor in the Watergate scandal. And at the time, and that was in 1991, I should say, it was the emergence of the so-called mega firm, which is now become synonymous also with South Africa, where you have mega firms in South Africa. And the firm had 4 offices. It's a Texas-based firm, 4 offices in Texas, one in Washington, D.C., one in Riyadh, Saudi Arabia, one in Geneva, and one in London. I worked in the office in Washington, D.C., in the International Law Department, where I gained experience working on the North American Free Trade Agreement between Canada, the US, and Mexico, which you would have seen recently Donald Trump wants to get out of as fast as possible.
Briefly, how did that contribute in sharpening your forensic skills?
Well, Chief Justice, I was fortunate to have been also at Harvard and having had not training but observing trial advocacy. And my forensic skills were particularly sharpened in practice because on international law, I had never been exposed to what happens when you negotiate contracts, when you negotiate treaties, and it also helped me coming to the bar in dealing with issues. I was fortunate to get one case from the state attorney regarding the finding a foreign vessel with a gill net, or or a trawl net, which was illegal under our law.
I noticed that practicing at the Cape Bar, you rose to the leadership position.
That's correct, Chief Justice.
Did that responsibility enable you to contribute to the transformation of the bar, and if so, how?
Well, I was strange that it's an interesting progression, so I'll keep my answer brief. I applied for membership of the Cape Bar as a member, and I was asked by various members because it was time for transformation. And I'm talking now 1995, 1996, thereabouts. And strangely, I was not elected to the position. I couldn't understand it, and only after the 50-50 situation with AFT, when we insisted upon equal representation, when we insisted upon equal governance, the answer was always, well, you don't have the numbers. And of course, the short answer to that was, we don't have the numbers because historically we were prevented from having the numbers. We didn't come from backgrounds where we had uncles or fathers who were judges or people in the profession that helped us to the bar. At the time when I started at the bar, there were only about 20 of us. But we insisted on equal governance, as was the position also in the GCB. So it was a natural progression from there. And one of the first challenges when I became chairperson was that there was a racism report written by the JP at the time to the then Minister of Justice, Ms. Mabandla. And in dealing with that, and I'm sure the President of the SCA will identify with this, is that I immediately convened a conference on gender sensitivity and race sensitivity. And the opening guest speaker was Justice O'Regan. And we had a number of judges that attended that conference. And it was a start to get people to think differently about race and gender, particularly at the Cape Bar. And so my progression then was first as vice chairperson and then chairperson for 2 terms.
Did that enable you to contribute in some way to the transformation of the bar?
Absolutely, Chief Justice. We started, for example, under my watch and that of my predecessor, the third junior project, where we would engage a third junior and a fee-sharing arrangement. We also had a policy under my watch when we had the provision made for women advocates when they go on maternity leave, that there would be relaxed bar dues, there would be relaxed floor dues, there would be relaxed a rental payable for persons simply because they were not in the same position as males. We could all go and carry on with our practices, but they, females particularly, were prejudiced and took a knock when in fact they went home to have children. So, and there are members, of course, in this body who can attest to that. My policy was always to empower black women. I can tell you that in the 10 or so years that I practiced as a silk, I practiced only with black women juniors. I had 1 white junior, and that was foisted upon me by the attorney. For the rest, it was my policy to, because I am hard on skills. I'm hard on advancing particularly black women advocates and providing them with skills and creating a pool of excellence. And I'm pleased to say that in a limited way, I was able to contribute.
You sound relaxed now. When were you appointed permanently as a High Court judge?
I was appointed on the 15th of February 2013, Chief Justice.
So you've been there, you've been a judge, High Court judge for about 5 years?
Correct, Chief Justice.
How was your experience as an acting judge of the Supreme Court of Appeal? Did you find it to be a welcoming environment? What do you have to say about the SCA as a place of work?
I must say that I always had a very collegial and it was a very collegial and very friendly environment that I encountered. And let me say immediately, I found that a very hard job. That job is not easy.
Yes.
And you will appreciate, Chief Justice, when you write a judgment and you mull over it and you agonize over it and you read it once, you read it 100 times. You see if something can't be said better. You make sure that you don't have contradictions between certain paragraphs. That's not an easy job.
Yes.
And but I must say that, when I wrote my first judgment, I in fact said to colleagues, here's the judgment. Please give me your comments, and in brackets, and criticisms. I was quite happy if somebody came to me and said, well, what do you think you were doing here? I really didn't have that difficulty. And I got on exceptionally well with colleagues, and I can tell you it is an extremely pressurized environment. Let me give you a simple example. Next term, we have 12 cases. Each one of us will have 12 cases. I'm assigned to write 3 judgments. Some are assigned 2, some are assigned 3. It's pressure, and you've got to get it right. And you write for the rest of the country, and you must make sure that whatever you say is right on principle. So to answer your question, I had a very friendly environment. I'm aware that, of course, there were others that did not, and I do not for 1 second want to suggest that that's a perception. It's very real for some people, as the President Maya has referred previously to this body prior to the conference that you had on race and gender sensitivity in January, in the first term, I should say, in February of 2017. I asked her whether I could attend the conference, but it was only open to permanent judges. But it's a very collegial atmosphere. There's an open door policy. You can go to colleagues, you can discuss matters. If you run into difficulty, you can ask. And one attribute I think that one needs in that place is that you must be teachable. The day you say, I actually have arrived, is the day you hang up your robes. So I had this policy that if I don't know something, I would ask.
President Maya?
Thank you, Chief Justice. Good morning, Justice Schippers.
Good morning, President Maya.
Tell me this, you are from the Cape Flats.
Yes.
How did a young man from that background rise to the heights which you have reached? How did you not end up in a gang?
It's a very appropriate question. I come from Bridgetown, which is on the Cape Flats, and it's a township similar to Hanover Park or Manenberg. And it is separated by the N2 from Langa. I was one of 7 children. I am one of 7 children, 3 boys and 4 girls. My father had no education. My father was a cutter in the leather industry, and my mother was a housewife. As recently as a week ago, Justice Maya, I was discussing with my brother, and we were laughing about the fact that we never lived as siblings alone, ever. And that was because there was always somebody else who needed a home. Let me give you a simple example. I had 2 cousins. Their mother was tragically killed, and my parents took them in. My father worked for them, raised them as his own. And we worked out that over the years, there was something like 14 people that lived with us in a 2-bedroom house in a township. Of course, growing up was easy, and it's interesting that you refer to gangs, because I had a friend, and out of respect for his family, I shall refer to him as John. John was very talented. He was a brilliant soccer player. He was a brilliant gymnast. In fact, I envied him. But one day when I came home from youth, it was a Saturday night. It was about 11 o'clock. John had gone off the rails. And there John was busy attacking somebody with a knife. I went to him and I intervened and said, you can't do this. He had already inflicted 2 wounds on the stomach, and we were able to go to a shopkeeper and phone an ambulance and get the injured person to hospital. Sadly, about a year or 2 after that, John was shot dead by the police. He was wanted for robbery and rape. Now, you may ask, how does one overcome this kind of odds? And Chief Justice, I can summarize it in 2 words: God's grace. I was grateful to have a mother who taught me 3 things that I will never ever forget. The first is dependence on God. She had a famous text, and some of you will appreciate the Revised Standard Version. It was Psalm 121. I will lift up my eyes unto the hills, from whence cometh my help. My help cometh from the Lord. So she taught me dependence on God. The second thing she taught me was to pray. And I could, even in practice, call on her and ask her for prayer. And she would say, hold the phone, let me pray. When I had a difficult case, whether I was in practice or whether I was on the bench. The third thing she taught me was that your character and not your circumstances define you. So I started out at UWC, Justice Meyer, and then I had to leave because I was there for 2 years, and I reminisced about 2 weeks ago with a senior colleague at the SCA. We did Latin together, and there was no money, so you had to hike to university regularly. And it was really tough, and that year the university sued me for my fees. I remember that time there was still imprisonment for civil debt. I had not complied with payment of the fees, and I landed up in the deputy sheriff's office to go to, waiting at 3 o'clock to go to Pollsmoor prison if, if nobody comes with money. I phoned my sister and she sent somebody, and it was a rude awakening, because around me were people, fathers and family men, who were there for debt and were going to be imprisoned because they hadn't paid and were going to spend whatever days, 15 or 20 days in Pollsmoor. I left UWC and went to the University of Cape Town because I got a bursary. But because the curriculum was different, Chief Justice and President Meyer, I had to take an extra year, and I was allowed to do 2.5 courses, and they gave me a bursary in the princely sum of 400 Rand. We're talking now 1980. After 1 month of attending lectures 3 times a week, I went to them and said, I'm sorry, I can't waste a year. It's too long. I need to finish my degree. So I registered with UNISA that March, and I did 5.5 courses that year, and the following year did another 4 courses and finished the BProc. I went back to UCT to do the LLB, but then I was offered articles, and that was 2 years, and then I did that. And while doing articles, I finished my LLB, and then after that I did the LLM. That was also part-time. And my first stint back at full-time study was when I got the Fulbright scholarship to go to Harvard. So, in a nutshell, that's my story.
You are still very involved in work with disadvantaged communities, and you do a lot of community outreach work, not so? And you mentor troubled youth and that kind of thing.
That's correct, President Meyer. I have in fact started 2 things. One is I regularly go to my high school. I'm often the guest speaker at their matric graduation ceremonies, and we were part of an alumni group, so we continue to encourage people from the community. The second thing is that a week ago, or rather a few months ago, I joined up with a ministry called Lamppost Ministry. And what Lamppost does is that they go to street corners and they put out chairs with tables and soup. And the idea is to have conversations with people. And interestingly, I went to one in Bridgetown where I grew up. And we chat to people, and inevitably there's somebody in the group that has the same experience as some difficulty of a member of the community. It's a way of spreading the gospel. It's a way of really reaching out to the community and going to, taking the gospel to them, which they otherwise would not hear. I have, as a result of that, they had discussions a few months ago, and I'm going to meet on Thursday coming with somebody who is involved in Hanover Park. And this is a pastor of the Pentecostal church. They have a project called Ceasefire, which is a technical project based on Chicago and the US, where they can determine where gunfire is erupting, or where shots have been fired. They then send in what they call interrupters to deal with, to diffuse the situation and to mediate between rival gangs. I have spoken to him because I want to start the Lamppost Ministry in Hanover Park. And in doing so, I was told as recently as last night that there's a new project called Character Company, And that project is trying to deal with intervention before people slip through the cracks. In other words, children, boys of 5 to 10 years old are then mentored by adults. 3 boys are mentored by adults to prevent them from coming into conflict with the law. So the lamppost ministry, hopefully in Hanover Park, will be launched shortly, where we again go to street corners, talk to people, and share the gospel with them, pray with them, and so forth. I should also say that the minister of the church to which this project is linked has indicated to me that whenever they go into the township, or they do what they call a prayer walk, where they simply just go into the various houses, ask people if they need help, and pray with them, they found that people have said, it's quiet, the community is a bit calmer when you are here. So it does make a difference, and I hope to get involved to a great extent in that ministry. And then, as you know, with my brother, who's a Baptist minister for the last 40 years, we have a project in Kenya where we work to train women and pastors in scripture and in theological training.
Before the President's next question, now that I'm confident you're relaxed, if you could be as brief as possible. If more detail is required, there will be a follow-up
I will
question.
be brief. Thank you,
Thank you
Chairperson.
so much.
Thank you, Chief Justice.
Does your involvement in this kind of work ever interfere with the execution of your judicial function?
No, it does not, Justice Meyer. As you will be aware that when it's an extremely pressurized environment, judgments have to get out, and I've never ever had a situation where, in fact, I've been called upon, particularly at the SCA, where I've been for 5 terms now, to produce a judgment because it's long outstanding or because there's been any delay.
Thank you, Chief Justice.
Thank you, President. Commissioner Malema?
Covered.
Minister?
Thank you, Chief Justice, and good, is it morning, afternoon, Justice Schippers?
Good morning or good afternoon, Minister.
Is it still morning? Justice Schippers, I recently observed a presiding officer who, at the end of that observation, I said, there goes a taskmaster, and only realized that that person was you, and that was a matter where you almost sent counsel packing for poor preparation of their papers and not even having read some of the documents, etc. What is your view about what the judge should or shouldn't do in cases where a counsel or a legal practitioner does their client a disservice by shortchanging them in that manner? Is it sufficient to just reprimand the counsel in court, or is there something more to ensure that ultimately justice is served on those that deserve it?
Minister, to answer your question, there is, of course, you do reprimand counsel in court. The difficulty that you have is that unprofessional conduct does not necessarily encompass slackness and laziness. But I think that for most part, I've always tried to, and it costs nothing to actually speak to the practitioner afterwards. And if I do find that the case has been really badly presented and that it warrants it, I would make mention of that and hope that it doesn't happen again. Because ultimately, and particularly when it comes to counsel who represent government, because ultimately it's taxpayers' funds that are on the line.
I'm asking this because there's a perception that certain judges are a little bit too hard on counsel, do you think that in a situation where counsel is basically not doing the job, the judge is well within the right to be hard on them? Or is there some degree of restraint that judges should exercise? in
Well,
that regard?
to answer your question, Minister, you must obviously treat counsel, it goes without saying, civilly. But it does not, one of the easiest things to do is to say quite civilly and have the debate. And when the debate, as the debate proceeds, counsel will soon get the message that they are being of no assistance to the court.
And finally, my third question relates to transformation at the Cape Bar in particular. I need not give you the stats, but it is clear that there is woeful underrepresentation before we even talk about silk status
Yes,
when it comes to race and gender.
yes.
Now, a quarter of a century down the line, what is it? Put aside what's already been spoken of sufficiently on the role of the state. Can you just, for a moment, reflect for me on what actually happens in the profession itself in terms of inclusivity? Do you believe that the profession is doing enough to ensure that when White Council gets work, it brings women in, it brings junior black people in? What is the situation in your own experience?
Well, I'm not very familiar with the situation, particularly at the Cape Bar, but I can say this, and it is a well-known fact, because I've seen this also at the SCA. The perennial problem, Minister, is briefing patterns, and also making sure that skills are imparted. Because I find sometimes, even among black counsel, they don't engage black women juniors. And it is extremely difficult for these people to develop practices. Speaking for myself, I regularly go to UWC and always encourage final year LLB students, I normally do it almost annually, to come to the bar to make sure that there is equal representation. That's one thing, but for them to survive, they need work. And the problem has always been that briefing patterns were skewed.
Thank you, Chief Justice.
Thank you, Minister. Judge President Japi?
Thank you, Chief Justice. Well, good morning.
Good
Judge
morning,
Schippers.
Judge President.
You know, it is said when one gets appointed to the bench, you take your background with you.
Yes.
When puny judges normally talk about the approach of the SCA compared to that of the Constitutional Court, we often said, well, the approach of the SCA is the approach of black letter lawyers, and the approach of the Constitutional Court infuses elements of equity in the law. Bearing in mind your background, where would you say you would come down, Judge Schippers?
I would say I come down firstly on the side of upholding the Constitution. That is the oath of office that I take. That is the law the supreme law that I am in duty bound to uphold and apply. I wouldn't say that I am a black letter lawyer, but what I would say is that I've always striven to err, if I do err, on the side of the Constitution. And I think that particularly when I started out in 1993, when we were just about to become a democracy, the striking thing to me was that many judges didn't have what I would call a constitutional mindset. If you have a constitutional mindset, it colors and it shapes and it infuses your judgments, and you will make sure that whatever you do is compatible with the Constitution. I don't for 1 second say that your background doesn't influence the way you think, but ultimately, if the lodestar is the Constitution, then I don't think you can go wrong.
Thank you, JP. Commissioner Ntlama?
Thank you, Chief Justice. Good day, Judge.
Good day,
How are
Commissioner.
you?
I'm well, thank you.
Yes. In your questionnaire, you made reference to your LLM thesis, which has been published at UCT.
Yes.
What qualifies as a publication?
Well, I suppose if it was of the nature that it deserved publication, then they would publish it. And secondly, if, simply put, there were funds available, and Suko at the time provided the funds.
So was it published as a book or as an article?
No, it was only published as a dissertation like everybody else's dissertations. It's not really a fully blown publication.
Thank you, Prof. Commissioner Masuku?
Thank you, Chief Justice. Good afternoon, Judge Schippers.
Good afternoon, Commissioner.
Judge Schippers, we've shared many cases as your junior in Cape Town. And as a black junior in Cape Town, I found a brother in you, and not a brother that would lack the attribute of impartiality in adjudicating your application here. But you were prepared to help black juniors, not just from just appreciating the cultural alienation that they experienced in the environment of the Western Cape Bar. As your junior, I remember one moment, you even wrote me a letter, a formal letter, under your letterheads, because I delayed to give you heads of arguments, which I needed to give to you as early as possible. And that's how rigorous you were about and how serious you were about taking the work. But the most important question I really want to ask is, what do you consider to be the non-negotiable attributes of an appellant judge? And of those that you identify, which one would you consider to be your particular attribute that you would bring to the Supreme Court of Appeal should you be appointed?
I think one of the most important non-negotiable attribute is that you must uphold, you must maintain your independence fiercely. Secondly, you must apply the Constitution as effectively as you can. And thirdly, you must treat litigants and practitioners civilly. I can tell you that in previous years, and I can say this without any fear of contradiction, that particularly under the presidentship of Justice Maya, that this is significantly abated and in fact doesn't happen. But previously, people would say this when they appeared in the SCA, that they were dismembered by a judge. That's not good. It's wrong. And litigants must be treated civilly, counsel must be treated civilly, and I think one of the characteristics of a judge is humility and teachability. And I hope to bring that to the bench, and also to be of assistance when it comes to acting judges, for example, struggling with writing judgments and so forth. Because it's an institution that we are there to protect. It's the integrity of the institution and its honor that must be maintained.
Thank you, Chief Justice.
Thank you so much, Commissioner Masuku. Commissioner Singh?
Thank you, Chief Justice. Good day, Judge Schippers.
Good day, Commissioner.
Thank you. I note that you've been appointed judge in 2013.
Yes.
But you've been acting from 1998, so that's a long stint that you've had in acting. and that you are acting judge of the Supreme Court from November 2016 to now. Have you relocated to Pretoria? Are you still resident in Cape Town, and how do you manage the traveling, and how will, if you are appointed, it impact on your family life?
Well, what we normally do, I've been in the SCA now for 5 terms, and I understand that it's going to be until the 3rd term of this year. What I do is what most of my colleagues do, Commissioner, and that is that we live at our homes and we live in Bloemfontein for the time of the court sitting. So I understand that it's something like 5 months of the year. So recess, we will take all our records, go home, read them. And may I say this, there's a perception that when judges go on recess, they go on holiday. That is not so. In fact, you've got to start reading all your judgments for the next term. As I've indicated, the next term starts on the 1st of May, and all the reading must be done before then.
Well, if it's any comfort, the same perception applies to us, members of parliament. When they, when they say recess time, and journalists are here, they know, they say we're going on recess for 2 months. Meanwhile, we'll be hard at work in our constituencies. My second question, my second question relates to the fact that there are a number of cases that take far too long to be finalized in courts,
Yes.
especially at the High Court level. What do you feel are the main causes for some of the delays, and what can be done to ameliorate these conditions?
I think one of the main causes of the delays, Commissioner, is the fact that there are not effective case management. There is not effective case management in that court. The Chief Justice introduced case management a few years ago, and I can say in the Western Cape, it has worked. For example, you can get a trial date quite soon because, for example, what I used to do, for example, in the road accident fund matters, on a Friday I would go through something like 30 or 40 files. Make sure that the case is ready, make sure that all the procedures that need to be followed and that can be disposed of so that only the court deals with what is in issue. All of that can be done before the time. That happens both in criminal and in civil courts, and I think the answer is really effective case flow management.
Thank you, Chief Justice.
Thank you, Honorable Singh. Commissioner Nokesi.
Thank you, Chief Justice. Judge, it's a question around the judgment you made. Of course, this matter was later on dealt with. You made a finding that the powers of the public protector were not binding, and that led to interpretation in the society, politicians, upon reflections and having regard to the subsequent decisions of the High Court and of the SCA and the Constitutional Court, would you say, what would reflections would you make in relation to whether those that hold the view that you actually held over that were correct?
Well, you're talking obviously about the DA versus SABC case and the powers of the public protector. My starting point was that it was modeled on the ombudsman, and that was based on a decision by the Constitutional Court in the certification judgment. I said that the public protector's powers were not binding and held that, by the same token, I said they were not mere recommendations and had to be followed unless there was a rational basis to depart from them. The both the SCA and the Constitutional Court said I was wrong, and I accept that. And it seems, and that is why, Commissioner, I granted leave to appeal, because I knew it's a topical question, it's a difficult question, and another court might come to a different finding. And can I just make this last comment? It also illustrates that our system of appeals works, so that when a High Court judge gets it wrong, the SCA and the Constitutional Court can correct it. And that I take as a positive from that judgment.
Now, my last question it relates to the application of the customary law.
Yes.
Customary law is the living law, is the law of our people. But there is a tendency to relegate the customary law into an inferior law, and also in the application, you find that there's an infusion of the principles of common law to customary law. What could be your advice in the course of applying customary law where it finds application?
Commissioner, you raise an important point that customary law has been neglected. Previously, as you correctly point out, it was a branch of the common law. But Section 211, I think, of the Constitution makes it clear that courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So yes, customary law is a body of law that must be allowed to develop and thrive.
Thank you so much. Just Schippers, you're excused.
Thank you, Chief Justice. And thank you, Commissioners.